Nellenback versus Madison County. Counsel.
Good morning, Your Honors. May it please the Court, Hillary Nappy on behalf of the appellant. Your Honors, this case...
Counsel, just for a minute, do you want to save any time for rebuttal or no?
I'm sorry, Your Honors, yes. 3 minutes, please.
3 minutes, yes.
This case presents a very simple question: whether the clear red flags presented in the record are enough to establish that a jury should be able to decide.
And what are those red flags?
Yes, Your Honor. So starting with the testimony of Ms. Hogue, who was the supervisor of Call Hawk on record site 127, she acknowledges that the job duties of the caseworker were to meet with the child in an effort to reunify the family. He was also supposed to meet with the family. He was supposed to provide counseling and arrange services and transportation for mental health and court appearances. He was supposed to document his visits for the purpose of report writing and even testifying in court. Ms. Hogue also admittedly said that the training that she received and the direction she received with how to manage her division was learned by...
With respect to the failings that it seems that you're going to, as to following the protocols, what about those failures gave a clear indication that there was an issue here?
So, Your Honor, it is the totality of the circumstance coupled with the lax environment of this division that allowed Mr.
How
Hogue...
do you get from the type of behavior that was engaged in as against the child based on a failure to document information?
The failure of documenting the information is not necessarily what led to him to be able to conceal his behavior.
Well, how do we know that the documentation was not made as opposed to lost in the interim period?
The file was otherwise relatively complete. We had visitation records showing who went to visit Mr. Nellenback at the group homes that he was at. There were notes from providers in different homes that he had been assigned. There were even logs that showed in discovery other transportation that did not occur with Mr. Hogue.
Was that the court file or the DSS file?
The DSS file.
And
Go ahead, sorry.
Go ahead.
How would we know from that missing material, why would they have had reason to infer that abuse was occurring as opposed to, looking at the logs and seeing whatever the time allocated was?
So the notes should have encompassed, and our expert provided a report, the detailing of the interactions spent with the child, what was happening, what was discussed, what progress was being made. If Ms. Hogue had supervised Mr. Hogue, she would have been able to see the nature of the interaction, the frequency.
It seems to me you're talking about two different points here, but correct me if I'm misunderstanding you. One is, what do we see about her supervision? And the second is, what might the notes themselves have revealed? Is that right?
Correct, Your Honor, and I'm focusing on her ability to supervise someone who was unknown, albeit later on,
what
convicted
exactly,
child sex offender.
And what exactly in the record shows that she failed in her supervision in a way that, had she fulfilled her obligations, would have given them reason to think that he was engaged in this conduct?
She consistently testified that she did not review the notes,
Well,
that
she
did not...
also testified that
said
she
regularly
had
looked at
face-to-face meetings with him. So why is the note-taking superior to the actual meetings that she had face-to-face, where she could assess credibility, she could look at him, she could understand what was going on, and there was no requirement that she...
I think, Your Honor, and I understand the court's point, but part of Mr. Hogue's job responsibility was to create these reports, to monitor progress for further assessment. If other needs were met, if the child needed additional mental health services or further supervision, with the goal that he might have to actually testify in court or prepare a report.
Did she ever summarize any of these meetings she said she had with him?
She did not.
So there's no record of any conversations?
Correct.
Dates, times, what she
Correct.
might have asked?
And she did not remember or recall who Mr. Nellenback was, despite the fact, as counsel likes to point out, that it was a smaller caseload with a very close-knit unit. There were several boys that were part of an investigation later on.
Did she say she met with the victim?
No, no one met with Mr. Nellenback. There was one question
I thought
by a
she,
counselor.
I thought she stated that part of the intent of the supervisory approach was to develop a positive relationship with the children so that they would be very candid.
That's correct,
Did
Your
she
Honor.
explain why, how she could achieve that goal if she never met with them?
She did not, Your Honor, and it was left to the caseworker, with the supervisor having discretion over what ultimate decisions would be made. And that feedback was coming directly from the caseworker.
What evidence can you point to in the record that would suggest actual knowledge of sexual abuse?
I don't believe that there is actual knowledge of sexual abuse in
What
this case.
about constructive knowledge?
Yes, Your Honor, so that was why I was laying out these red flags. In a totality of the circumstance, you have what the goal of the caseworker was. You also have Ms. Hogue explaining that because she was learning by the seat of her pants, to quote her, you need to look at the entire picture. And so keeping the goal in mind, there was a lack of documentation of these visits. If we look at the
Counsel, I mean,
record.
I think we've all looked at the record, and we understand, and my problem is, even if I accept your assertion that the supervision was deficient in certain respects, and we can say that the record-keeping of the supervision was wholly inadequate, I still don't understand the leap to that would somehow disclose evidence of the type of notice that you need to go forward in this case.
So if we look at Mr. Nellenback's testimony, he testifies that the sexual abuse occurred almost immediately, within 2 weeks of his encounter with Mr. Hogue. I think that testimony and the fact that it had occurred over a period of years, always in these clandestine-esque visits that were not for the purpose of where he was supposed to have been through these transports. It falls in line directly with the case law that we're seeing coming out of the Second and Fourth Department, which focuses on the frequency and nature of the abuse and the ability for a jury to question whether the supervision of the abuser and the lack thereof allowed that abuser to conceal his true efforts.
So the
with child.
opportunity to conceal abuse equates to constructive notice of abuse? Is that what it comes down to?
No, I think it's just one sign of it, Your Honor, right? In this particular instance, you have to take all of these pieces together, right? There is a very clear focus of what Mr. Hogue was supposed to be doing. There were state guidelines.
What do you mean by that, a clear focus of what he was
His
doing?
purpose was to provide services to this child to reunify him with his family. Yet, on the very base level, he never documented, so we don't know if he ever met with the family. And there are no documents or notes concerning the progress of his meetings with Mr. Nellenback, which would have potentially included some of the signs that were noted in the
But
other
that
parts of
last
the record.
point, maybe you can say more about that. As Judge Canataro said, if we were to accept that there were deficiencies in the record keeping, how then does that lead to constructive notice for the agency at the time?
So I think the record is replete, and I think it's undisputed that Mr. Nellenback was receiving mental health counseling and needed further services. The progress notes that Mr. Hogue should have been documenting would have included that. It would have included.
Where does that get you to the final step?
Yes, Your Honor. So if Mr. Nellenback were experiencing any of the mental health symptoms or signs that are commonly associated with child sexual abuse, and it had been documented, and Ms. Hogue had read them or spoke with Mr. Hogue about them, perhaps intervention would have happened and actual notice would have
So
happened.
speculative.
I understand, Your Honor. The point that I'm trying to make, though, is that without those progress notes, which should have been there is no way that we can tell how Mr. Hogue, Ms. Hogue supervised Mr. Hogue.
So what is just to be clear from your perspective, what is the notice that's necessary, that constructive, notice of what? Just to be clear.
I think it's notice in this particular case, right, of whether or not, it's not about propensity, I think, in this particular situation. I think it's the question of whether or not Mr. Hogue was being supervised appropriately. All of these facts go to a question.
Notice of what is the judge's
Because you said
question?
not propensity, which seems at
it's-
odds with their position, but no, what are the red flags?
Well-
I understand, red flags that there's lack supervision, if any, I get that point. But then notice of what? That the child maybe is in danger, or that this gentleman is just not doing his job?
I think it's both, particularly in this case, because this was a child
have to show-
The question is
predisposed.
what matters legally? There has to be constructive notice of something to matter legally,
Correct, Your
right?
Honor.
So it's constructive notice of what that matters legally?
I think Mr. Hoke's failure to do his job was actually also a red flag because the behavioral pattern that might have been established, right, that he was taking this county vehicle, not going where he was supposed to go, not taking the child where he was supposed to take him.
It seems to me like you're talking more about causation than you
Well,
are about notice.
Your Honor, if I just may finish my sentence, because I hope that it will answer your question. That would get you to the fact that he was concealing his behavior, and for what purpose?
What
Which I
about
think
the
was
fact-
his propensity.
Yeah, but
That
What
same
about the-
behavior could be concealing drug use or something else. Like how, where's the linkage to this sexual assault?
Your Honor, I think that would have come with the mental health evaluation of Mr. Nellenback.
You said he wasn't doing his job. What about the records saying that he was commended for doing good work?
Well, I think that goes to the lax performance and performance reviews that Ms. Hogue also said was not taken seriously, right? It was just a pro forma job review. So without documenting progress of children that you are tasked with supervising and coordinating services for, I'm not sure what the standard was in terms of job performance that led to a commendable performance. I just wanted to point out.
But let me ask you this, other than the fact that you don't have notes from the caseworker, which, yes, a supervisor maybe finds that disturbing, but put that aside for one moment. Are there other records that, perhaps in combination with the lack of note-taking or proper record-keeping, might have put the county on some type of notice?
I believe so. I mean, and I would point the court to record 266, 267. Those are the visitation records showing that Mr. Hoke was not either visiting or signing in and memorializing when he was actually making contact with the child. Unfortunately, he's deceased, and we couldn't explore that particular answer through a deposition.
What about, what is it that Dr. Nuno, your expert, looked at with respect to the victim's behavior?
So he examined the DSS and court file that we received, showing the mental health progress notes, showing Mr. Nellenback's time at George Junior Republic, which coincided with some of the abuse. There were clear indication of certain behavioral outbursts, which together are classic signs that we now know, and I think that they knew at the time, indicated that the child was in distress.
So to be clear, these are notes taken by the staff?
Yes,
And then where do these notes go?
they were in Mr. Nellenback's file.
Which would have been available to?
Mr. Hoke and Ms. Hogue, which is actually where I wanted to point the court. Dr. Nuno's report is also very clear, I think, on what the best practices were with respect to supervision, and it coincides with the New York State standards. And that is,
Your time is up, counsel.
I'm sorry, thank you, Your Honor.
Thank you.
May it please the court, my name is Kevin Martin. I represent the respondent, Madison County. And I
What
think
do you
maybe I'll.
say with respect to the suggestion that there were records, in fact, with respect to his psychiatric or psychological care, that if reviewed properly and the other record keeping had been done, clearly established that there was an issue with this child?
So I probably should have emphasized this a little more in the briefing, but this was a PINS case. So the parents of Mr. Nellenback petitioned the family court for assistance, and an order was granted. So the family court was in control of the records, not the DSS. So the family court.
I'm a little confused. There are records regarding the type of conduct that, at a minimum, seems associated with a child's potential sexual abuse. These are records about behavior at the Children's Home of Jefferson County. The county has no interest in knowing what is going on while the child is in.
No, I didn't say that. So we actually work with the counselors. So Mr. Hoke, just to correct one thing, he did not give counseling. He's not a counselor. He's not certified. The counseling was provided at the group home, initially in Watertown, New York, at Jefferson, the Jefferson home, and then subsequently at the George Junior Republic in Freeville, New York, and following that, a Tryon over in Johnstown, New York. And so,
These are private homes,
correct. And so,
but they're overseen by the county DSS?
correct.
Okay.
Correct, exactly. So, and we would work together to create a plan, which would be updated with, and if you look at,
So you're working together?
Yes,
So
and
the
if you look at
staff
the
on
rec-
this site documents this various types of behavior, urinating in bed, wearing diapers. I mean, I don't have to go through them. You know what they are in the record, which are signs of potential abuse, sexual abuse. What, the county does nothing?
so.
Would
there-
that not have perhaps notified the county that it should take further steps?
I don't recall that there was anything in the UCR reports to that effect. And again, the UCR reports are family court records, which are retained by the family court. They are not DSS records. Now, we have an interest in them.
So what
We
are
review
the
them.
DSS records?
So the DS record that we were able to find, we provided, but it wasn't a complete file. So essentially, under the retention rules, once an individual turns 18, you retain those files for 10 years and then discard. So Mr. Nellenback was born in 1982. So his DSS files were actually discarded in 2010. And I think probably because of Mr. Hoke's subsequent arrest, there were some records which were retained, which we turned over as best we could. But as Mike Fitzgerald testified, the records were gone by 2010.
But at
So
the
all the work
time
was
that-
done.
But at the time that he was in custody, what type of information was available to DSS with respect to his care and well-being?
So they had copies of any reports that were prepared by the Jefferson home up in Watertown. They had copies of reports prepared by the George Junior Republic when he was there, down in Freeville. And then some of the services we provided were quarterly visits to these group homes to check in, how are things going, talking with the counselors at these group homes and those who were providing specific services to Mr. Nellenbach. So we kept on top of it.
So again, if you have access to those documents, you're keeping on top of it. In those documents, for a particular child, there is documented, there are notes indicating behaviors that are associated with potential sexual abuse. What does the county do?
I don't know that there was such notes.
Let's assume for one moment it had that kind of information. What would the county do?
If there was any inkling
Yes,
that there was sexual abuse
yes.
by our employee particularly, we would do exactly as we did in 1996 when we found out that there was a problem with another person.
But
This is not-
I appreciate that, but that was not exactly my question. My question is, you just have access to documentation, you said the county stays on top of it, you have access to documentation where there are notes indicating the kinds of behavior that are associated with child sexual abuse. It doesn't say who's the abuser. So what would the county do? I'm just asking what the protocol is.
I presume there was no testimony about this? There's nothing in the
Dr.
record?
Nuno's
I mean,
has an expert
about what the
report about
protocol
this.
is.
Oh, I'm sorry.
There's
I'm
no
sorry.
testimony about that
Okay.
in the record on appeal. And, I presume at the time,
Yes, but your position is you don't have notice, so I'm asking about something that looks to me
well, we
like
had
notice.
notes is our position. We had notes. And those notes were destroyed
No,
in
no,
2000.
not notes, notice,
Oh, notice.
yes. It
No,
seems
I
to
don't-
me these are things that would perhaps provide notice. So I'm asking what would the county do?
I don't believe anyone was on notice of child sexual abuse as a result of those notes. The professionals who were providing the services in Jefferson County, in Tompkins County, in Albany County, or I guess it would be Fulton County, those folks would be the ones to tell us, hey, there's an issue here. We're not sure where it's coming from. It could be from other students at our group home. It could be from school. Who knows? But that would be brought to our attention, I think, by those professionals. Carl Hoke at that time, he's a caseworker. He's providing occasional transportation. That's it. He's not providing counseling.
Were they required to log that transportation, the use of the county car?
The use of the county car was logged. It wasn't necessarily logged that, there was a discussion in the car, or he said this or he said that, unless there was something notable. I imagine there would be.
Well, like, for example, if they were taking someone from point A to point B, and that should have been a 15-minute ride, but they log it in, and then 2 hours later, they say they deliver the kid. So that might be something that would raise a red flag. I don't know, I'm just asking, was there a requirement in that sense, or just a note a county car was used?
Yeah. I don't think it would raise a red flag, and it's kind of sad, quite frankly, because, I think we see these cases with different eyes in 2025 from what we would have seen in 1993. And quite frankly, for a young man who was having the kinds of mental health problems, criminal charges, things of that kind, it would be admirable for someone to take extra time,
No, I
try to spend with the
appreciate
child.
that, and I
So it wouldn't
appreciate,
necessarily mean anything.
Counsel, I appreciate how we have evolved on these issues. My question is merely, would there be a requirement of a logging in? I took the car at this time with a student, and I dropped it off at this time. That's all I'm asking.
I don't believe so. So multiple trips were taken sometimes. So someone would take the car in the morning and deliver 3 or 4 kids. So Ann Hogue testified about that. So she'd have the car all day, but she would make 3 or 4 different trips. Or she would, go out of state. So the time spent was so variable that I think the main purpose of the log, to be honest, is to get reimbursement for expenses and just to track where the vehicle was.
But
Because
isn't that in part the argument that there was a culture of sort of this lax, almost non-supervision because there wasn't appropriate record keeping, there weren't protocols established that might allow a supervisor who is properly trained to see that maybe there's a problem with the way this caseworker is handling this case, maybe there's a bit too much attention to this particular child?
in 1993, there were no protocols about how to handle transportation logs. All of the training that was required by the state of New York was done. It evolved over time. As we pointed out in our brief, Ann Hogue was hired in 1968, 5 years before the passage of the Child Victims Act, or Child Protection Act, in New York State in 1973. And she evolved as the law and the facts, and all of us have learned over time of what's possible. So like I said, we see things with different eyes today, but there were no protocols in
The
93.
statute was already an indication that the legislature thought there was an issue, and of course, as we know, although we wish everything moved faster, that would have meant that there was a great deal of at least scholarly work on the issue.
In 1973, the focus was on physical abuse. So it wasn't until the early 60s that academic research was done, and it was focused on physical abuse of children. It wasn't until much later that child sexual abuse became an issue. So in 1986, the registry was created by the state of New York, where they started to try to track and that was still a physical abuse thing too, but they were trying to track situations where someone was accused of improper interactions with children. That was 1986. So Ann Hogue had already been working for 18 years before the registry was even thought of.
Yes, but of course, he's abused starting in 93,
Right, much later.
many years later.
Correct, that's correct. So, there was record keeping. It's been deleted in accordance with the Office of Child and Family Services rules, and they're kind of strict about it, actually. They don't like to have these things hanging around. It's not nice records, and.
Well, did she testify that there were work records, but they were destroyed?
Ann Hogue did not, but Mike Fitzgerald did. So he was the head of the department at the time this case was brought, and he worked for the department.
Did she testify she took records of her in-person conversations with the caseworker?
She wasn't asked that question, and
Well, she was asked about record keeping and notes, correct?
she wasn't asked if she made any notes or did any record keeping. I know that she did some notes because after Mr. Hoke was arrested, she ended up filing the UCR forms, which were required by the family court because Mr. Hoke was arrested in March of 1996. So,
With respect to the record keeping for the cars, it looks to me from your brief that you're saying that there were several pieces of information that had to be included, which seemed to me to turn mostly on mileage for reimbursement purposes, right? Meal vouchers, but not specifically times of pickup and drop-off. Is that right? And
I think it is correct.
do we know whether there were any regulations that specified whether it was in the, the ADM 43 or 80, whatever it is, the regs that were issued?
No such regulations about keeping track of the time. And again, if somebody was going to spend extra time with a child that was having difficulty in school, with criminal charges, things of that kind, why is that a bad thing?
Well, your adversary's argument, I take it, is that the combination of unaccounted for hours along with other signs of distress that he might have been exhibiting might have led someone who was reviewing it to ask some questions. But just in terms of the records themselves, it sounds like reimbursement, meal voucher, mileage location, and meal voucher, is that right?
And the simple fact of availability, so that if somebody signs the car out, it's not available for someone else to use, so that people oftentimes use their own personal vehicles.
But there's not a sort of hour-by-hour
No.
log in terms of how each caseworker has used his or her time?
That was not a requirement.
So if I could just go back to what you were saying about what was known at the time, and I take your point about learning with respect to sexual abuse of children, especially by those who the government has allowed children to have access to those children. But I think you said we certainly knew enough by 1993 with respect to physical abuse, yes? Okay.
Yes.
So if he is not taking notes, what would have been available to a supervisor or anyone on the county's staff to check whether or not the child was being subject to physical abuse in foster care or group homes?
So the testimony was he was taking notes, and that she was reviewing them. They don't exist because they were discarded. So there's no dispute about the fact that we were doing what was required.
Well, he might not write down that he physically abused the child, right?
I doubt
Well,
it.
you're right. So, yes, one would think he wouldn't. So
He
is
fooled
there-
a lot of people.
Yes, it's unfortunate. I understand what you're saying. Would there have been some other way if the caseworker is the one who's committing physical abuse? Would there have been some other way for that to have been unearthed?
I think the best way
Yes.
was the way that ultimately led to his arrest, and that's a good relationship with the children that are in your charge and their families, the counselors, and we did that. The only other
Well, who other than
possibility...
the caseworker had that relationship? Did the supervisor have that relationship with the victim?
Yeah, that was a testimony of Ann Hogue.
She met with the victim?
She met with the...
And the family?
She met with each child, she met with the family, she met with the counselors, she went to the facilities in Jefferson County and at George Jr., had a good relationship with them.
So your adversary spoke in error when I asked the same question?
I think so.
All right, thank you.
Thank you.
Time up. Thank you.
Your Honors, I'll be very, very brief. I actually don't believe I spoke in error. The testimony that Ms. Hogue provided was that on intake, she met with families. There was no further follow-up with Mr. Nellenback or his family. And specifically when asked after the discovery of Mr. Hogue's, I keep on doing that, I'm so sorry, Mr. Hogue's criminal activity, there was no follow-up with Mr. Nellenback. There was one incident which Mr. Nellenback testified to that he was asked specifically in the presence of his family and another caseworker who was unidentified by him in his testimony if Mr. Hogue had sexually abused him, and he denied it. And he was young at that age, which we know through tons of research that that's pretty typical. I just also wanted to point out, because I think that it is important for the court to understand, Ms. Hogue, while the statute in 1973 didn't account for sexual abuse, testified in her career she had worked with children who had been victims of sexual abuse, and she had worked predominantly with females. When I specifically asked her if she had worked with males and had experienced any males disclosing sexual abuse, she actually pointed to another victim of Mr. Hogue. So this was a person who had, and she testified about training that she had received through the state at Cornell to recognize the signs and symptoms. But it's our position that without the proper information or the proper follow-up by Ms. Hogue, she would not have known what was happening with Mr. Nellenback. And because there are no indication in the record that anyone else other than Mr. Hogue actually spoke to Mr. Nellenback at that time, his purpose of coordinating the transportation and the visits to different mental health providers or further treatment would not have been found. If the facilities were talking directly to the caseworker and the caseworker was purposely concealing his activity, it would not be documented. But follow-up from a supervisor might have revealed that. And because he was not the movement, we're just asking to be able to go to a jury. Thank you so much.